Thank you for joining us, Professor Colbert. What is your take on a hung jury here?
Well, I think we learned a great deal about what happened to Freddie Gray and what police practices need to change in order to make sure that the same injury and death does not occur to anyone else.
So court testimony indicated that former city police officers and current city police officers saying that general orders are guidance. We really get to use our own discretion whether or not to follow them. And I guess civilians would take a look at that as saying, really? What good are rules?
Well, and that's where the undercurrent of this trial was: who controls, who makes decisions? Is it the police union and officers on the beat, or is there a commanding police officer who tells officers the rules and expects them to follow those rules?
Now, the way it boils down now, I guess the post-trial, if you will, they're going to have to decide or have to figure out how many jurors were in each camp. Kind of take us through that process.
Well, I think what the prosecution must do in making a decision whether or not to retry Officer Porter is to learn what the divide was in the jury room. If it was in favor of conviction, then I would assume that there would be a retrial. And if the jury was very much on the defense side, then they would have to think twice before retrying it.
And if in fact it was more on the defense side, what options could the state then consider regarding Porter?
Well, Officer Porter will face administrative situations where they're going to review his conduct. But the state really has a situation here of whether they believe they can convict the individual. I thought the state had some very strong testimony against Officer Porter, but obviously the jury felt a great deal of sympathy, empathy for Officer Porter's situation, and gave him the benefit of the doubt that every accused person's entitled.
But how can Officer Porter now be useful to the state if in fact they choose not to retry him?
Well, if they don't retry him, the likelihood is that Officer Porter's statements will not be admissible at Officer Goodson's trial. I think Officer Goodson is one of the officers that has to be vulnerable to the conduct, to the allegations, because the charges against him were far more serious than against Officer Porter.
And you mentioned just a few moments ago that the prosecution made some pretty good points. Now, let's start with the two sets of statements that William Porter made, one to detectives and one to the jury.
The defense only had to convince one juror of a reasonable doubt. That's always the difficult part of prosecution role, but in this case, there would have been much more understanding for Officer Porter as a criminal defendant than the average poor person who's accused of a crime for whom there's much less public sympathy. And
obviously, without having an opportunity to speak with the jury, what do you make of they were hung? Okay, it's not unusual for a jury to be deadlocked. How many times could the judge have exercised sending them back? And what do you make of that he didn't do it?
Well, the judge certainly has discretion to tell the jury to give it one more try and to use strong language in the sense of, you are in the best position to render a judgment in this case. Judge Williams decided that the jury was unequivocal in its final decision, and I have a great deal of respect for the judge. So I think he had the information he needed to make that call. Now it's up to the prosecution. Where do we go next in terms of Officer Porter, and will the next trial be Officer Goodson as scheduled?
And let me ask you a question. How much knowledge is the judge allowed to have in these cases? Because the jury would pass a note. Obviously, the judge read it, and he shared it with both prosecution and defense, but he only shared a limited amount of information to the public. How much information is the judge allowed to solicit from the jury and go through that process a little bit?
Every piece of information the judge gets, the public receives, and the lawyers from both sides must be aware of that information. There are no secrets between judge and jury. What I'm saying is that the judge was able to assess the jury's role, felt that they did their best, they tried their hardest. There's some people in the jury, maybe one person, that really dug in on this case and decided on either side that they could not join the majority.
And as far as the jury being anonymous, all jurors start out anonymous during a trial, but at the end of the trial, their names are released. Is the judge's order in this case going to be indefinitely not releasing anybody's name? Is that your interpretation?
Yeah, that'll be your job and the job of media, or the individual jurors might well want to speak to explain themselves. That often happens. And if that does take place, we'll learn much more about the process inside and how many jurors were in disagreement with each other.
David, I want to ask you a quick question that
Stan
hopefully
Stovall has a question.
hopefully you can relay to Doug there. We were talking about Judge Williams having the discretion to say, okay, I see you are hung. This trial is now a mistrial. Would he make that decision based on, or maybe it gives us an indication, how split this jury was as to how quickly he decided, okay, I'm going to accept the mistrial or the hung jury?
Well, Stan has a question about the judge's knowledge. He assessed the jury rather quickly that they probably can't go any further. What kind of information would he have to make that decision?
Well, he'd have to feel that there was a real imbalance among the jurors, and that with the further pushing and urging that individual or individual jurors would be persuaded to change their thinking. For whatever reason, the judge's evaluation was they have deliberated long enough, they've done their duty, they've done a good job, they've been attentive, and we are not going to interfere with the jury deliberation process.
Do judges make this decision without perhaps direct knowledge, but based on your experiences, what do they make this decision on? What do they base it on?
Hey, David.
Well, a lot of the time the judge is probably thinking about the evidence himself and trying to think, is there a basis here, a legitimate basis for disagreement? And I think in this case, it being the first of 6 trials, the judge wanted to set an example that the jury's decision will be respected.
All right,
Hi,
David.
David.